Then the third topical issue, which is in the name of Deputy Dessie Ellis, and it's to the Minister for Environment, Community and Local Government on the eviction of local authority tenants. Deputy has 4 minutes.
Tenants in this state are not protected adequately from summary eviction or eviction with no justification, while legally councils can evict without due process. Section 62 of the Housing Acts allowed local authorities to adopt a summary procedure for evicting local authority tenants without a requirement to justify that decision before a district court or an independent tribunal. This section was deemed by the Supreme Court in 2012 to have been in direct contravention of the European Convention on Human Rights. Specifically, it was found in 2 cases to be in contravention of Articles 6 and 8. The right to a fair trial, and everyone has the right to respect for his private and family life, his home and his correspondence. In April 2013, Minister, you said a bill to repeal Section 62 would be before the Dáil that year. We still have not seen it as the year's anniversary of that statement approaches. Right now, despite the ruling of these courts, there is a legislative backing in the state for a local authority to summarily evict tenants without any real justification, and in some cases in direct opposition to the public good and the rights of the individual and their family. The inaction of the government on this issue is particularly troublesome, while a number of cases in recent times show that the councils are in some cases still evicting people without proper fair hearing and without justification. Even if Section 62 was repealed, there is a need for legislative protections for tenants from eviction, given the devastating effect this can have on people and its potential to put people out on the streets. In Kerry, November 2013, a pregnant woman who was unemployed and had problems with alcohol was evicted by the council and forced to find shelter in emergency homeless accommodation. This was despite a district court order being secured. It was in violation of the UN Bill of Rights, which states evictions must be a reasonable and proportionate response, subject to due process and fair procedures, and subject to a further state obligation to take all appropriate measures to ensure that evicted individuals are not rendered homeless. This month, Sinn Féin councillor John Brady received an eviction notice from Bray Town Council. His family now have just under a month to vacate their home. They have lived their 13 years without issue and are an important part of their community. The reason given was that they had done work to their home over 10 years ago, when the council had told them they had not had the funds to carry out the work themselves. This eviction notice comes after a prolonged period of campaigning by Councillor Brady for the rights of local authority tenants in the area, which saw him undertake an occupation of the town council offices with 2 women who had been made homeless with their children. Another case is that of Patrick Colopy of Limerick City. Patrick Colopy, 26, who was living in Bishop Street, has been told by Limerick City Council that he will be kicked out of the home he shared with his mother Rita until her death last year. After her sad death, aged just 40, Patrick received a phone call from the council telling him that he must vacate the house on the grounds of the 2-year tenancy rule. He's been up to date with his rent and has never been in trouble with the law. In these cases, evictions were not fair, they were not reasonable, and they were not in the interest of the wider public good. This is why we need protections for tenants. It is why Section 62 must be repealed. It is why the PRTB, as the RTB, should be given remit to work with council tenants.
Deputy, the Minister's 4 minutes.
Could I thank Deputy Ellis for raising this matter, and certainly there are issues that you've raised, Deputy, that I found most interesting. I just want to point out, though, that each housing authority is responsible under Section 58 of the Housing Act of 1966 for the management and maintenance of its own housing stock, and therefore it would be inappropriate for me to comment on management issues relating to particular dwellings, as I have no function in individual cases, and under the Local Government Act of 2001, local authorities are subject to law, independent in the performance of their statutory functions. So in the two cases that you've raised, it would be inappropriate for me to comment specifically on those cases. But I would like to set out the position regarding the law under which local authorities repossess their dwellings following termination of tenancies. Section 62 of the Housing Act 1966 currently sets out a summary court procedure for this. This procedure withstood constitutional challenges over the years, but the enactment of the European Convention on Human Rights of 2003 resulted in further challenges. The Supreme Court declared in February 2012 that Section 62 is incompatible with the State's obligations under Article 8 of the Convention by reason of the absence of procedural safeguards where there is a factual dispute as to whether a tenancy has been properly terminated for breach of the tenancy agreement. Section 5 of the 2003 Act provides that a declaration of incompatibility does not affect the validity, continuing operation or enforcement of the statutory provision in respect of which it is made. Nonetheless, I have reviewed Section 62 of the 66 Act in consultation with the Office of the Attorney General and Housing Authorities, and the Housing Miscellaneous Provisions Bill currently being drafted provides for a revised procedure for repossessing local authority dwellings. The new procedure will involve an independent hearing of the merits of the proposed repossession where there is a dispute about the basis of terminating the tenancy, which is often the case where antisocial behaviour is involved. The Housing Bill, which also provides for the new housing assistance payment and a new tenant purchase scheme for local authority housing along incremental purchase lines, will be published in the coming months with a view to being enacted by the summer. Deputies will therefore have an opportunity in the near future to debate fully the new procedure for recovering possession of local authority dwellings. The bill will also include measures to strengthen the powers of housing authorities and approved housing bodies to secure court orders excluding from their dwellings and estates individuals engaged in antisocial behaviour. And just on the last point you made, Deputy Ellis, the legislation currently going through the Oireachtas will bring tenants of approved housing bodies under the PRTB, and in the future we would want to bring tenants of local authorities in under that, but we haven't been able to do the whole lot in the one go, but certainly in principle we would agree that is the next step in the process.
Thank you, Minister. Deputy for
Yes,
supplement.
I'd like to thank the Minister. I think the Minister knows that there is an urgent need for the district courts or an independent authority to judge each case on its merits, to be able to question the reasons why an eviction is being sought, and not to have, things like a rubber stamp as previously has happened. While we accept evictions may take place, and there may be reasons for going after an eviction, whether it's an antisocial issue or otherwise, it is imperative that legally these mechanisms are put through a legal process, a robust legal process, and a means of judging them on that basis. I think it's very, very unfair that we have in the past that we have a procedure that can't be challenged. There's no input in terms of residents, there's no input in terms of tenants, and it was more or less just put into the courts, and it was passed through the courts. So there's no mechanism to scrutinise each case and to look at it on its merits. At the recent Constitutional Convention, they recommended that housing is a right. I believe housing is a right, and that where there are cases we have to put in place mechanisms. If we have families that end up being evicted and there's a proper procedure in place, we have to have a proper mechanism to deal with them, and we have to have a way of following up with those families. It doesn't mean that they should end up homeless. It doesn't mean that just because a person gets put out on the street for whatever reason, we still have to have a mechanism to deal with those families and to deal with them in a proper way. And I think that's the crux of the issue, because I have experienced, and many people have experienced, neighbours that cause major trouble in their areas, and the local authorities have tried to evict them or otherwise. I don't want to see a rubber stamp that those people are evicted. I want to see a proper legal mechanism to deal with it. and to be above reproach and above just hearsay or otherwise. I think that's extremely important. Thank you.
Yeah, I mean, as you say, Deputy, this is a balance that we have to strike, because in some cases there are people who make a misery of the lives of people around them, and as you know, in the Residential Tenancies Bill, we are going to make it easier for so that the person who lives next door doesn't have to directly confront the people who are causing the problem, but that, say, a residents' association, for example, can do it on their behalf. And I am in the course of the housing bill, which will be published and will be debated here before the summer. We will have we'll be addressing the issue that was in Section 62 of the Housing Act, which was found to be in contravention of the European Convention on Human Rights. So we will address it there. There are individual cases, as you say, that are distressing, obviously, for the people concerned. But it's a question of trying to get the balance right, because we have to have, in the small number of cases where people do cause misery to their neighbours, we have to have a mechanism there as well. But we will have an opportunity to debate these issues when the housing bill comes before the House.